first case on this morning's docket. That is case number 104520, State of Kansas v. Scott P. Roeder.
May it please the court, Rachel Pickering, public defender, on behalf of Scott Roeder. Chief Justice Nuss, if you could please reserve 5 minutes rebuttal time.
5 minutes is granted.
Thank you. There were several issues raised in Mr. Roeder's brief. We have 8 regarding the trial and 4 regarding the sentencing. This morning's argument, I've asked for 30 minutes to go through the first issue regarding the failure to instruct on voluntary manslaughter. If time allows, the second issue, but I must address the hard 50 sentence that Mr. Roeder received, which we believe is unconstitutional in light of the recent United States Supreme Court case, Alene versus United States. And so with that, Chief Justice Nuss, I'd like to just jump in and go right to the robust argument regarding the voluntary manslaughter instruction. So, in Kansas, since 1992, the legislature brought in voluntary manslaughter and allowed someone who actions, when are done in a unreasonable but honest belief that circumstance existed that justified deadly force in defense of another, may, if there is sufficient evidence shown, some evidence shown at trial, be instructed on this lesser included instruction.
Here, what circumstances existed?
I'm sorry?
Here, what circumstances existed that would justify deadly force under those 3 statutes listed?
Well, we have unreasonable but honest belief. We have imminent harm.
Okay, stop. Can I stop you right there? Unreasonable but honest belief in what?
That he reasonably believes the use of force is necessary to defend others. And that is from Ordway. So it's combining this voluntary manslaughter with the self-defense instruction. And Ordway says putting those together, voluntary manslaughter is intentional. Now,
And then as I interrupt you, go back to finish your list. I'm sorry.
okay, the list.
Let's back up. The statute 213403B speaks to honest belief that circumstances existed that justified deadly force.
Correct.
Under the 3 statutes listed.
Right.
And the honest belief is that circumstances existed. Not a belief in what the law should be, but the circumstances existed. And I'm asking what circumstances did the defendant honestly believe existed here that fit within one of the 3 statutes?
Well, the circumstances. Well, let's read the statute first before I start defining it. That would be a better way to answer your question, Justice Johnson. KSA 213211 provides circumstances when the person is justified in the use of deadly force, when a person reasonably believes that such use of deadly force is necessary to prevent imminent death or great bodily harm to such person or third person.
What
Okay.
circumstances existed here
We have
that would support deadly force under that statute?
under the statute, we do have imminent harm. We have procedures that will happen within 22 hours to which these unlawful procedures, as Mr. Roeder saw it, unlawful, he saw it as unlawful, given the crimes, given the charges that were against the doctor, that lives would be taken within 22 hours. So there is
unlawful because they did not follow the statutory procedure.
Correct.
Now, can I get a clarification? Is that clear in the record? Or was it just 22 hours that there would be an abortion? Do we know if that would have been an abortion that would be lawful under the statute?
That was his view.
His view, but we don't have anything that would go to the point that Justice Johnson was just making, that it would be an abortion that wouldn't follow the statutory procedure, do we?
Right. Well, we do have his view that these abortions, and this doctor is known for doing late-term abortions. So the certainty is there that these abortions will be illegal in terms of Mr. Roeder's viewpoint. This isn't just a simple abortion clinic. This doctor specialized in these type of abortions.
But there was no, is there anything in the record that establishes that it would be a late-term abortion that would be occurring in 22 hours from the time of the shooting?
All we have is Mr. Roeder's viewpoint that the abortions that this doctor were performing the next day were going to be unlawful because he saw the doctor's practice as unlawful in terms of these late-term abortions.
So any abortion?
No, late-term abortions. He thought the doctor was performing late-term abortions the next day. That's why it was unlawful. The state did not contest that. The state did not present evidence from people from the clinic stating that 22 hours later this would not happen.
Okay, now, this, given that, what under the statute would make a late-term abortion that violated the statutory procedure to do that justify deadly force? In other words, if you violate statutory procedure, does that trigger the right to use deadly force to stop a procedural violation?
Okay, in Mr. Roeder's mind, and we look this from an unreasonable but honest belief, in Mr. Roeder's mind, these abortions that were taking place, these late-term abortions, were being done unlawful in light of the charges charged by the former Attorney General and the present Attorney General's office. These types of abortions were unlawful because...
But Dr. Tiller was charged with misdemeanors for violating the statutory procedures. He wasn't charged with murder.
Correct. Correct.
And so I'm asking is, even if that were true, even if he were convicted, and even if he were doing that, would that, under the statute, the statutory definition of defense of others, would that have been permitted?
Absolutely. You can't separate the two. A misdemeanor for failing to follow that procedure resulted in what? In Mr. Roeder's mind, the deaths of others, the lives being taken. So to say, well, we just have 9 misdemeanors, how was that a life taken? In Mr. Roeder's mind, these were deaths occurring.
I think my colleague's point is it isn't the unlawfulness that your client believed was occurring, the unlawfulness in terms of violation of the procedure that was causing the death.
Correct.
That he felt he needed to prevent. It was the procedure, it was the fact that the abortion was going to be performed at all. That's
Well,
what he wanted to prevent, isn't it?
Well, I want to make sure that we're clear. He's not saying that abortion in general is unlawful. This is not where we're at. We're not back to the state of Shannon where the defendant can't say that it's unlawful. We're saying in Mr. Roeder's mind, given the 19 charges and an acquittal of the doctor, that these procedures he was doing, albeit misdemeanors, allowed the doctor to continue to perform these, what he saw, illegal abortions. I don't think in Mr. Roeder's mind he's differentiating it as you are doing right now. So I want to get back to...
But don't we have the principle that everyone's presumed to know the law?
Yes.
And so the defendant's mistaken belief about what the law allows is not how I read the statute. The statute says the honest belief is about the circumstances that existed, not about what the law permits. You understand what I'm saying? If he had a honest belief that the circumstances would have fit within the statute, and they would have fit in, then that's what the statute addresses. It doesn't address an honest belief that the law is different, or an honest belief that the law should be different.
Oh, no, we're not even there. Justice Johnson, we're not even that the law should be different, that the legislature should step in and change abortion. We're not even there. We're talking about his view that this doctor was performing illegal abortions resulting in the death of others. So the circumstances existed justified deadly force. He thought this doctor was performing illegal. And I'm repeating myself, but I do want to address your question, Justice Johnson.
So you think that the circumstances can include a mistaken belief about what the law is.
No, no, we're not at mistake, and that's something that the state tried to bring in its brief, that the unreasonable but honest belief is a mistake. We're believing that he has this unreasonable but honest belief that the doctor is performing illegal abortions.
As a legal matter. See, I'm trying to separate out facts from interpretation of law. And if you're trying to say that he had an honest belief as to what his interpretation of the law is, and his interpretation was that this was an unlawful practice, to me that's an honest belief and a mistaken interpretation of the law. That's all I'm getting at. And is that under circumstances talked about in statute? That's the question.
Well, I quibble with the word mistake to begin with. Not a mistaken, it's a belief. He had a belief that the doctor still was committing unlawful abortions. His belief...
He had a belief that the law was being broken.
Correct, which resulted in deaths of others.
And it's an honest, but I'm just trying to get down, it's an honest but mistaken belief that, that part, it just seems like it's...
You can, in these cases, you have cases of a father thinking that, our grandfather, white, thinking that his grandson is being sexually abused. He could have been wrong, but he still, for other reasons, he raised the voluntary manslaughter instruction in perfect defense of others. He could have been wrong about that abuse, but he did try to stop it. Here...
Why shouldn't the result be the same? In White, we said no.
You said no for different reasons. You said no because the child wasn't there when the grandfather went and shot
And so if we find that 22 hours later is not imminent, then you lose?
Well, I would
Under
argue...
White?
Under White isn't a full... isn't the right case I want to look at in discussing eminent harm, and I'd like to jump into that right now. The setting of this argument really needs to be, are we looking at sufficiency of evidence? No. We're looking, sufficiency of evidence you get to look at from the light most favorable to the state, and you could have circumstantial evidence. Here, we get to look at it in the opposite view. We get to look at it from a jury instruction requested. So, unlike the state, we look at it in the light most favorable to Mr. Roeder.
How do we factor in the fact that Mr. Roeder's defense, in large part, was to prove that his belief was reasonable, not unreasonable?
It was trying...
I mean, he wanted to call Mr. Disney, he wanted to call Mr. Klein, he wanted to call other witnesses to prove that other people agreed with him, that from an objective standpoint, it was a reasonable belief. How does that factor into this issue?
They also said it went to the honesty of his belief. Where did he get to that? Because that proof that you just talked about would have assisted me in answering Justice Johnson's questions earlier about how are 19 misdemeanors leading to unlawful activity. They were trying to show the basis for it, why he had this belief. It's not just an unreasonable belief of, I think tomorrow the sky will turn gray. Well, actually, will probably turn gray tomorrow. Some other unreasonable belief. But they were trying to show the basis for this. Where did this come from? And that also triggers the time period. Because here we are, we have Mr. Roeder being a pro-life activist for many years, and what triggers it? What starts him on this path? And that is these charges made against Dr. Tiller. I was trying to give you an answer to the imminent harm, and I want to get the time, how we want to look at this. We have a time frame of 22 hours. Imminent has been defined as more than immediate. In one hand, we have Hernandez, a 1993 self-defense case, which says it has to be danger near at hand. But that's a self-defense case where we're looking at it objectively. Here, we have something else. We have it from a subjective point of view. A jury can find that 22 hours is imminent, because imminent is more than just time. Imminent concerns certainty. So we have a time frame of 22 hours, which so far the only definition we have of imminent is danger near at hand and more than immediate. So we're still within that time frame. We see it from a subjective point of view. A subjective point of view that the district court erred on. He saw it from an objective point of view and therefore disallowed the instruction. So we look at from a subjective point of view, Mr. Roeder's testimony. In fact, that was all, you look like you're about to ask me a question.
Well, I guess I'm confused. You said a jury could find 22 hours to be imminent based on the definition of imminence.
Oh, I apologize. Based on under the right circumstances. Under the right
But
circumstances,
then you talk about subjective belief,
yes.
and what the jury has to believe, if we buy your argument that the legality is what he believed it to be, then the jury just has to believe what the defendant believed. They don't have to make an objective determination whether 22 hours is imminent. Or the flip side is then it's an objective determination that would be amenable to our looking at it objectively rather than a factual determination.
I'm going to cite to you a Maryland case, Marr, to answer your question. What may be unreasonable, so this is what the jury would look at, is the perception of imminent danger. So, or the belief that force employed is necessary to meet the danger. The perception of imminent danger, that is what makes it unreasonable. But we also do get to provide, the jury looks at it, the jury can be advised that this is, since you're looking at it from the subjective, what did Mr. Roeder testify to? If you take the subjective part out of imminent harm, you're taking away their perception of imminent danger.
Who gets to define what eminent means?
Well, that's the interesting point. The legislature hasn't done that for us.
How have we defined it? How have the cases defined
So
eminent?
far, we've only defined it as imminent as more than immediate, and that is in that's in Hernandez, and then in White, we took a look at 2 California cases and said it has to be danger near at hand. But unlike those California cases, those were danger that may occur in the future, and that's something I want to
Is that
talk about.
Melendez, the California case?
The 2 California cases of probably Enright, Christian, and Menendez.
Menendez, yeah.
Talk about those cases are quite different from here because in those the harm may occur in the future. For the 2 brothers, they may be harmed by their parents. Here we have certainty, and that's the third part in this paradigm I wanted to craft for you. We have a time frame, we have subjective basis, and we also have certainty. Mr. Roeder is certain that these illegal acts which cause death will happen in 22 hours. There is a certainty there. Unlike in White, where he shoots the man he thinks is going to abuse his son, the son's not even there. And Hernandez,
There were not going to be any abortions performed at the church.
yes,
And that's what White said. White said the boy wasn't even at the place of business, and so there wasn't going to be any abuse visited
Yes.
there. So what's the difference here? I mean,
there's quite a big difference because what you've just said is what the district court ruled in denying this instruction. District court said how is eminent within the time of the church. We get to look at this from an unreasonable but honest belief, subjectively, defining it more than immediate, and a certainty here.
So is the message of your position is that a premeditated murder of a person is a less serious offense if it's motivated by opposition to whatever the defendant or the perpetrator believes could be fatal to someone? In other words, if someone believes, has a fervent belief that smoking kills, and it's killing people every day, and it's going to kill people within the hour, within the minute, within 22 hours, that gives someone the right to go out and kill the CEO of Philip Morris because they believe that's what they're promoting. Is that And
That's not what the legislature-
does that entitle someone to be held accountable less than first-degree murder?
I don't think that circumstances of this case fit the Philip Morris scenario to begin with.
Well,
But
it might not
still-
be exactly the same, but it's the same principle.
But
A person believes that what is happening as a result of the actions of this person is killing people.
Right.
And even though the actions are lawful under the law, it's killing people. Does that somehow subject that person to less than premeditated murder if it's a cold-blooded killing?
Well, you have to remember, all we're asking is a jury instruction. We're not arguing sufficiency of evidence, Justice Rosen, that there was sufficient evidence to support this in terms of a really high standard. All we're doing is our jury question. This is why you bring in a jury to ask these common sense questions.
Well, you're claiming it's a defense.
Well, I apologize. It's not affirmative defense like self-defense, to be clear. A voluntary manslaughter is still murder. You are still being, the legislature has made sure that somebody who has these honest but unreasonable beliefs that deadly force is necessary, and they see this danger at hand, that they are still punished.
But the answer to the question is yes. The answer to the justice's question is yes. They're less culpable.
Yes.
They're
Yes.
less culpable if they believe, no matter how twisted the belief, that they're saving lives. So you can kill the CEO of Philip Morris and get a voluntary manslaughter verdict, and that would be okay with you. That's your argument today.
I don't think it's in that, I don't see it that black and white, Your Honors. I see it as.
How's it different? How is the
Because you've made it-
hypothetical, excuse me, how is the hypothetical posed by my colleague actually different from what you're proposing today?
Because the CEO is himself not, the question of whether they're unlawful changes. And you're putting us in the same scenario
I don't
as
think so.
Shannon.
I don't think so, because at the time that this murder occurred, the procedures being performed by Dr. Tiller were legal procedures.
Yes, I understand that, but he was
The
charged.
CEO is doing a legal thing when he promotes the sale and consumption of cigarettes.
Correct, but he is not, that CEO is not performing procedures on people specifically for which he was charged that they were unlawful, leading to their deaths.
There have been numerous lawsuits where the tobacco companies have gotten verdicts in their favor.
Right,
So why wouldn't that, let's add that to my colleague's hypothetical.
right.
How's it different?
It's too far out. I mean, we have so
So
many
22
factors.
hours isn't too far out, but the fact that it's a certainty that many people will die today of lung cancer because they were smokers.
No, because you
I mean, you
removed-
keep arguing certainty. It's just as certain at this stage of the game
you've
that
removed-
smoking kills people.
Yes, it does. Smoking kills people in time, not a procedure that will happen quickly.
So the fact
The next day.
and that's your distinction, just that.
No,
That
there's
there's an
more.
instantaneous result as opposed to a result that's virtually certain to occur over time. That's the distinction. Do you have any other distinctions from my colleague's hypothetical?
Absolutely. You're talked about the tobacco litigation. Did you have a thought that there has to be a link with that tobacco litigation? That's more false advertising, isn't it?
Let's say there was a link. Let's say that the day before the CEO is murdered in cold blood, a verdict came down in a class action. In
That
which
he
the tobacco
himself-
companies defeated the plaintiff, who was the widow of a smoker who
You've
died
taken-
of lung cancer.
They're quite different because you've taken again, who is the aggressor here? The aggressor is someone who's performing abortions. Here, the aggressor in your scenario is a CEO of a tobacco company. Okay,
I don't
why is
understand the use of the term aggressor in this
well?
context.
That's how we've defined voluntary manslaughter, haven't we? That this person sees this person committing this unlawful act as the aggressor.
Okay.
In white, the person accused of sexually abusing. So
Okay.
you've made the CEO the aggressor, that he himself is creating these cigarettes.
I'm with you.
Okay, so you
So
have a distinction.
I'm looking for distinctions.
We have a distinction in terms of how you've looked at the aggressor's actions to begin with.
How so?
I would argue that a CEO of a tobacco company doesn't have the same abilities to put others in harm as the doctor did here in Wichita. That's a very big distinction.
And you would say that, why? I'm just trying to understand. If you accept the underlying premise that smoking kills, this person's life's work is to promote smoking and to sell cigarettes to people who will consume them and eventually die because they did so, what's the difference? Other than time.
We have a time factor. Again, I
So
think,
what time is acceptable and what time is not?
well, that's for the jury to decide. That's the whole point of this argument is we're trying to get this to the jury.
Let's take that point. The overall consideration here for any entitlement to a lesser included instruction under the Kansas statute is whether a jury could reasonably convict of the lesser included crime that your client here was requesting instruction on.
Right, it's some
So
evidence.
just, well, would a jury reasonably convict? And just so I understand your point, it is your belief that a jury could reasonably convict of the lesser included offense that your client was requesting an instruction on, and they therefore would find that 22 hours away from the crime, that was an imminent danger.
Yes,
That's your position.
yes. A terrorist on a Topeka bus coming tomorrow morning, you know it's going to happen, you know it's certain. A person could find that to be imminent danger, that we're in imminent danger of that occurring. A doctor telling you your father is going to be taken off of dialysis, his kidneys are going to fail, his death is imminent. That could be hours. The legislature has not defined imminent. It's more than immediate. And so we can put together, under the right circumstances, a subjective viewpoint with certainty going to happen that 22 hours can be seen as imminent.
And if Dr. Tiller, for example, had decided to take a 6-month leave from his practice, and your client knew that the next possible alleged late-term abortion would be performed 6 months later, is that an imminent danger that would justify the taking of the victim's life?
No, it isn't. Under Kansas case law, we've taken a look at that danger needs to be near at hand, and I would argue 6 months is not imminent because the further an event out is, the less certain it is that imminent harm will take place.
And at what point between the 22 hours at issue here and the 6 months of my hypothetical would you say, okay, I understand the jury does not get to make that call?
This court has not answered that question yet for us.
I'm asking you.
I know. I've looked and I've seen 2 weeks. There's a Pennsylvania case. It's not cited. I could bring you the site where they said 2 weeks out, that's a question for the jury. So 6 months is very far out because the certainty of it occurring is less.
What's the best Kansas case you have in terms of length of time?
The best case, Kansas case I have, I think, is Hernandez, where he was going to be shot that morning at 11. So he knew that the defendant knew that the aggressor had yelled at his wife 3 days beforehand, and all these events were occurring. I think Hernandez is a nice way to look at what is imminent.
Why not look at White? You don't want to talk about White, but why not look at White?
Well,
And in White, we talked about presence. When we were talking about imminency, we talked about the fact that the defendant, the victim wasn't even in the presence of the little boy.
right.
So he could not have hurt him. And we
Yes.
seem to indicate that immediacy meant even presence is important. And so we clearly don't have that here.
Actually, we have presence,
But we have presence
Justice Moritz, in terms of
of the victim. I mean, I'm sorry, we have presence of Dr. Tiller, but we don't have his presence in a setting that would allow him to commit.
we do 22 hours later. That's the difference between White.
But 22 hours doesn't indicate immediacy under the terminology of White.
Because White,
We don't have the patient present, is what I'm saying. In that case, it was the little boy that wasn't present to be abused. In this case, we don't have the patient present at the
Right.
church
right.
to receive the abortion
Right,
or the late-term abortion.
right,
And
right.
so that's what I'm saying. We seem to indicate that that presence was important in White.
Absolutely, but my point is, we do have presence 22 hours later.
Well, we don't know in White how many hours it would be before the person that's shot is going to be with the boy that's alleged to be
Right.
abused,
Right.
and presumably when he left work and went home, he would be around the child, which would be within 22 hours. But that wasn't the focus. Justice Moore's question is that the focus was at the time the deadly force was exercised, there was not an imminent or a scenario where the perceived unlawful force could have been exercised. And that's the same way here, because there weren't going to be any abortions at the church, just like there wasn't going to be any abuse at the place of work in White.
Yes.
And what
There-
we're trying to do is have you distinguish why White shouldn't apply here.
And distinguish between immediacy and certainty. I think you're conflating the two.
I'm not conflating the two with respect, Justice Moritz. I've given you a case where they said eminent is both. There's immediacy and certainty.
Well, let's talk about White,
Okay.
because I think you agree we have to have immediacy. And in White, when we talked about immediacy, we talked about the lack of presence
Let me clarify.
of the perceived victim.
Eminency is more than immediate. Okay? That's why I say 22 hours can fit in that under the right circumstances. Now, I keep on harping on certainty, and you're saying, tell me why you're talking about certainty. Because certainty brings in the presence of these lives that are in danger. Okay? So in White, he doesn't know when his young grandson is going to be abused again. That imminent harm, that unlawful harm, is in the future. Here, we know that for Mr. Roeder, it would happen 22 hours. So that puts the presence of the aggressor with the victim. That's how I keep on talking about a certainty. However,
We didn't focus on certainty in White, and that's my point. We focused on immediacy and
Right.
presence
right,
as a separate requirement, essentially.
right, and Justice Moritz, there aren't a lot of cases on this type of defense. In researching this, I was really going through, rereading Ordway, White, Hernandez, and Requisition to carve out what has this court done. And so the point that I'm bringing in certainty is a very important point of the immediacy. So that's how I'm distinguishing White. He did not know when this next sexual abuse of his grandson would happen. He knew he could stop the aggressor then. In Mr. Roeder's mind, we have a presence of the aggressor and the victims within that time frame.
But you've acknowledged in the Chief Justice's scenario that 6-month vacation, that doesn't apply, but it's no less certain that he's going to do what the defendant was concerned about. It just delayed for 6 months.
Oh, actually-
if certainty doesn't apply in that scenario, why does it apply because it's 22 hours in your view?
6 months is too far out to answer the most simple way. And I've said this before. The further an event
It's
out
too
is,
far out because certainty of event is not part of the calculus for imminence.
Two different
I've
things.
given you case law that it is, that it should be part of it. Because look at Quayles. Quayles is the voluntary manslaughter case we have where this court did recently find imperfect self-defense. That was going to happen very quickly. It was a barroom fight. But there was almost a certainty of a weapon being used. And so to say an event is imminent, the reason why we need certainty is because
Explain that again with Qualls or Quails. What was the certainty there?
he thought that a weapon was going to be drawn. He thought that there was going to be he had to defend himself.
He thought he saw a weapon being drawn
Right.
in Quails.
Correct.
So that was the imminency part
And
of
the
it.
certainty to it. That adds to the certainty.
But there wasn't certainty because there wasn't a weapon.
Yes, I know, but we're looking at it from a subjective point of view, that they're looking at this, that there was imminent danger. We don't have to prove there never was a gun in that person's hand at the ballroom fight. What did they think at the time?
If we consider certainty, are we back into that line of cases about with the necessity defense, where the Court of Appeals at least has looked at such things as interventions, the sidewalk interventions and other things as causing it not to be certain?
I'm not sure how the certainty goes back to the necessity offense.
Because there are there are things that can cause the abortion not to occur. A change of mind because of the counseling that occurs or a variety of other things.
The necessity to defend others is he was faced with a choice of evils, that he acted to prevent imminent harm, and then he reasonably anticipated casual relationship between his conduct and the harm to be avoided. So
But in
that's your
those
point.
cases, in talking about imminence of harm, they have basically looked, are there possible intervening circumstances that would stop the act from happening? And in the cases from our Court of Appeals, they in Holick, they looked at those sorts of things that could stop the act of the abortion occurring, and said that in that situation there wasn't the imminence that would allow the necessity defense.
Oh, there was not eminence? Right, and here you have to have both. We are not back to the point of that there was
No, they were saying that factor had not been met
the eminence part.
because it was not certain, it was not imminent because of those intervening causes. And I'm saying, isn't the same true if you use the word certain? It is not certain because there could be interventions that would stop the abortion.
I want to frame your question. I want to make sure I get it right. The last part was he would not be certain because there could be intervening events to stop it. And so where are you drawing the certainty from? Okay. For Mr. Roeder, these events would happen the next morning. I've repeated that.
Well, Mr. Roeder, to try to fill in here, Mr. Roeder had testified that he had been a sidewalk counselor and that had been effective in some circumstances to be on the sidewalk as the people came up.
Right.
21 and a half hours later from when he shot, he could have been on the sidewalk and talked the person out of it, and then it would not have been certain to have happened. And he recognized that sidewalk counseling had stopped some abortions. And so how can you say that he had an honest belief that it was certain to happen when he also said that he had personally engaged
Oh, I get it now.
in activities that had stopped it
Right.
without unlawful or without deadly force?
Right.
That's the question. How can we be certain when there are other things that could have happened that would have precluded the abortion taking place?
Well, you have a short time frame. The next day, you have his own background of trying to stop people from having abortions being committed, and those who he was unsuccessful to. So I don't know how many people he was able to dissuade. You don't know. So there's I want to say uncertainty. I don't have enough. There's too many variables. Wait. In Mr. Roeder's mind, there weren't many variables, like you said, the sidewalk counseling. He had tried that. He didn't think it was successful, but in other cases it wasn't. And so for him, these abortions that were scheduled to take place, he did not see an intervening event stopping it but for him, in his mind.
And we're talking in his mind being subjective, and is that unlimited? You mentioned Ordway. Ordway, we found that you couldn't base the defense on psychotic delusion.
Yes.
And so we do know there is a limit
Yes.
to what you can subjectively believe. Is there a limit based on religious fervor? Or is there, is that unlimited? where do we draw the line on focusing solely?
I think the line starts with the jury, because they're going to get this question. Is this just him, a pro-life activist, acting out? Is this the first-degree murder, or is this someone who has these beliefs? And that's why the defense wanted to bring
Well,
it in.
It's in order way we said if the honest belief is based on a psychotic delusion,
Right.
it didn't fit.
Right.
So what does the honest belief have to be based upon?
A honest belief has to be based on, I'm going to go back to the statute. Honest belief that he or she reasonably believed, so not psychotic, not someone who has these delusions, not a schizophrenic, believed the use of force was necessary to defend others.
But reasonably is removed from the voluntary manslaughter.
Right, so it would be so it would be an unreasonable but honest belief. It's not a mistake. It's and I've defined it.
Well, my question is, doesn't that person that's having the psychotic delusion honestly believe that what is done needs to be done? Isn't that honest to subjectively, even though it's based on schizophrenia or some other outside force? But isn't it an honest belief for that person?
Well,
And if we say that can't work, then what is it that does work?
well, unreasonable is not governed by reason, not governed by madness. Yours is governed by madness. Yours is governed by a chemical imbalance, the psychotic person. Exceeding reasonable limits. Irrational, excessive. That's how unreasonable is defined in my reply brief. It is not a mistake. It's not a different opinion. It's not a different perception. That's how we should define unreasonable but honest. Again, Justice Johnson, I have to go back with, we don't have a lot of case law outlining this voluntary manslaughter and perfect defense. I see I'm out of time.
I've got another question. If you, under your view of the law, if my hypothetical would be a family in a hospital that's reaching an end-of-life decision with a loved one, and they make the decision to turn off the ventilator.
Right.
And a visitor, a stranger, doesn't believe you ought to turn off the ventilator. That's killing someone. Can that person kill the doctor, but right in the act of turning off the machine, and get your instruction on voluntary manslaughter? Is that a jury question under your view of the law?
So this person has a unreasonable but honest belief that the doctor is going to perform something that he shouldn't be doing, morally or unlawfully?
I don't know. What difference?
See, that's you'd have
Let's
to take.
say does it make a difference if it's unlawful? They don't think the right paperwork's been done, so
no,
that would justify shooting the doctor?
No, and the voluntary manslaughter, no, that wouldn't. The voluntary because we have already set limits on the voluntary manslaughter, that it has to be that they believed the use of force was necessary to defend others.
Oh, they believe it. They believe they got to kill that doctor before he turns off that machine. And it's imminent because he's about to do it. His finger's on the button, and he shoots him dead.
Mm-hmm. Shoots
Does
the
he-
doctors.
Yeah, does he
Shot-
get this instruction under your view of the law?
Well, we have. I believe I still go with whether that doctor is the aggressor is a question that the jury would have to ask, because it has to be.
So you're making it a jury question. I mean, that's my question is it a who's
No, I
making
don't
the
think you've
decision about this aggression stuff?
In your scenario, I think it's very far-fetched. And when the legislature enacted the voluntary manslaughter, they put it for somebody who had these unreasonable but honest beliefs. Since those 20 years since the legislature has been enacted, we have not had mayhem. We have not had people shooting doctors under your scenario and being allowed to be given this instruction because they're missing a lot of things
We had
that
one.
meet the elements.
Counsel, we had one here.
I'm sorry?
We had one here. It's undisputed. That's exactly what happened here. And that's what we're trying to figure out. So how is my colleague's hypothetical distinct from your situation?
Well,
The death of the patient is certain,
death of
which is
patient-
what you've said must be there.
the certainty.
Imminent. It's going to happen very shortly. So what's distinct between my colleague's example and your case?
Well,
You can't say far-fetched, because the day before the crime in this case occurred, we all thought it was far-fetched. We don't think that anymore. So what's the distinction, legally or factually, from his case to yours?
we would have a number of distinctions with that. First off, I would have to go through your scenario step by step of wondering whether, you say it's an unreasonable but honest belief, so we have that. Whether circumstances exist that justified. Here, this doctor is going to perform a procedure that will kill this other person. Okay? But you also have to ask whether they think that procedure is, whether they see that doctor as the aggressor. Here, Mr. Roeder saw the doctor as aggressor, performing an unlawful act. I don't know
The
if...
person sees the doctor as the aggressor because the doctor is moving toward the patient and going to flip the switch.
But is he seeing this as being deadly force being used against him, against the patient?
The patient can't breathe without the ventilator. The patient
Right.
will die without the ventilator.
I know there's a
I
distinction.
don't see a distinction. I mean, I honestly don't, because the problem I'm having is that you seem to be jumping back and forth between objectivity and subjectivity. And I read your argument to be all subjective, that that all of these elements that are in the statute, no matter what they are, none of them are viewed from the lens of objectivity. They are viewed from the lens of the belief of the defendant. And so it's a jury question is what you're saying. I don't see the difference in my scenario and yours,
Okay.
because I'm saying it's an honestly held belief as to all these elements. And so you're saying that this statute and this jury question will be applicable anytime someone wants to shoot a doctor in that type of scenario.
There are, this is not a defense. This is a lesser of first-degree murder. This person in your scenario will still be held accountable for, if you don't see a difference, for voluntary manslaughter.
I'm just trying to say, in your view of the law, does that defendant, in my hypothetical, get your instruction that you're asking for in this case? That's all I'm asking.
Well, you've already answered it because you didn't see a difference. I see some fundamental differences about how they see the doctor as the aggressor, whether they have this honest or unreasonable belief.
Is the view of the aggressor something that the court should look at objectively, or do we look at it through the lens of the defendant's subjective belief?
The view of the aggressor should be seen from the lens that this is subjectively, that this is that there is imminent danger. The view of the lens is that their belief, and this is from Marr, what may be unreasonable is the perception of imminent danger, which we've talked about, or the belief that force employed is necessary to meet the danger.
Okay. My scenario is still good under that point.
Under
So
Marr.
So keep trying. I mean, are there any other distinctions?
Not that I can think of right now, Justice Biles. I will this afternoon.
You've talked about, in response to several questions, you've talked about, well, the doctor is the aggressor in the situation that we're dealing with today, but in the hypothetical that Justice Biles posed, it seemed like you were saying, well, there the doctor is not the aggressor. And I was just going to say, my understanding of what was going on here and likewise with his analogy, is that in the situation before us, Dr. Tiller was performing these procedures at the request of the patient. Is that right?
Yes, so,
And the situation Justice Biles posed was that the doctor was flipping the switch on the ventilator at the request of the patient's family. Is that right?
under his scenario, yes,
Okay.
that's what he's told us.
And my question is, how under either scenario would the doctor be considered the aggressor when the doctor is complying with the requests of either the patient or the patient's family?
Well, it's what is the doctor doing? The doctor isn't simply removing a spleen, this doctor is ending the life. That's how it's seen as using deadly force. That his procedures is making this into a life or death scenario. And so that's how Mr. Roeder sees him as the aggressor. That this is a situation causing others, put others, and he must save their lives. So,
Okay, well, I was looking at something from the record from Mr. Roeder's testimony,
okay,
and he testified that, quote, "From conception forward, abortion is murder because it's not a man's job to take a life."
right.
So how do we know that someone with Mr. Roeder's beliefs would not intervene in the hospital situation Justice Biles was talking about, and to say, I'm not going to allow the doctor to take this patient off the ventilator because that will end the life, and it's not a man's job to take a life. So that takes me back to his scenario. How is there a distinction between the two? Can you elaborate on that? or are you
So
going-
what you've done in his scenario is put Mr. Roeder as the person who's going to stop the doctor? That's
That's
basically,
one possibility.
that's what
Or
your
someone
point.
who thinks like Mr. Roeder. Would you like to think about that and answer it on rebuttal?
Yes, if you ask it again. So his point is, what if Mr. Roeder was the one who did this hospital visit? Instead of going to this clinic, what if he went to a Wichita hospital and was looking for that patient who was about to die and set it up? I would like to address that on rebuttal. I'm out of time.
Yeah,
but
I want you to address too on rebuttal. I know you're out of time, but underlying all of this is that what you're really arguing is that someone's, albeit sincere, maybe well-intended, moral or religious beliefs can be justified in preventing a law-abiding citizen who's exercising his or her constitutional right. How is that fundamentally allowed? How can we allow that? And how then can you base a defense and request instructions based upon that very premise? Because it seems to me that unless you somehow carve an exception to that you just don't get a defense. You don't get an instruction based upon that premise, that you can't kill someone who's exercising their constitutional and legal rights, regardless of how well-intended you are. It's designed on preventing him from doing that.
Justice Rosen, I want to answer your question right now. What you've just done is carved out the state's case against Mr. Roeder.
I don't know if I've carved it out.
it's-
Then answer the question.
Because that's how the state addressed this. But the argument that the defense put together was one under the voluntary manslaughter. We did not look at his religious beliefs. That argument is not, what was he thinking in 92? This argument is not based on his religious beliefs or based on his moral beliefs. This is not the argument under voluntary manslaughter doesn't put Mr. Roeder in that frame of mind.
You just argued his religious beliefs.
you
A while
just-
ago, when you said you made the distinction because a life was being taken, under the law of Kansas, if you have a lawful abortion, it's not a life being taken. That's his religious belief.
Oh,
And so you made the distinction when you were answering one of the other questions that this case is different because a life is actually being taken. That's
Right.
his religious belief. That's not legally correct, which leads me back to where I was early on, whether his mistaken belief about the law or what the law should be gives him the voluntary manslaughter instruction, or whether he has to have believe in circumstances that would legally permit self-defense
Okay.
or defense of others,
Okay.
rather than a moral belief. And that's bottom line where we are.
Okay.
First question that was asked
Right.
an hour ago.
Is it been an hour?
Pretty
I
close.
don't know. Do I get to the hard 50 issue or not?
Not at this time.
I have filed a motion for supplemental briefing on this. The state argued that Hard 50 is unconstitutional. I hope to address it at rebuttal. Thank you.
Thank you.
May it please the court, Assistant District Attorney Boyd Isherwood on behalf of the state of Kansas, and I'd like to make a couple remarks if I could before we get into it. I think that what the court has hit on this morning is the case law from White. And not only did the court not focus on certainty in White, the court excluded it. One of the quotes from White is, "Fear of future harm, no matter how great the fear, and no matter how great the likelihood of the harm, will not suffice." So it's not just that it wasn't relevant, it's that it was excluded. And secondarily,
Could that mean won't suffice alone? I mean, could you read that sentence to mean that it's not going to be alone
well, I
enough?
think that takes us to what I think Justice Johnson illustrated.
Temporal proximity as well.
There's no, just like as in White, there was no indication that there was going to be some sort of molestation at Walmart. Here, there is zero indication that there was going to be an abortion performed at the church. They're going together. Thirdly, all we ever have in this case is a possibility that something might happen 22 hours from that time. And I think that a few of the justices have hit on that. It's only ever a possibility. And fourth, it seems like counsel was arguing, one, ignore White, two, change White. And the problem I have with that is the district court clearly relied on White. And to say that the district court, if you change today, Wednesday, what the law was for the district court to look at, I don't know how we can say that the district court erred in following White back in time.
But the problem with White, it seems to me, is some of the prior cases, Ordway and some of them, had indicated that we're really dealing solely with subjective determination, and that even imminence is a subjective determination. Of course, then Ordway went on and said a psychotic delusion doesn't fit, which doesn't make sense. But the point being is, we're back to what Justice Miles talked about, the subjective versus objective. If we're talking about an honest belief, that's subjective, but how do we put an objective filter on it? How does that work, and where you draw the lines? And
well, it's interesting to me that the term, I think the term that I'm involved in the discussion right now is imminent or imminence. It's interesting to me that term would somehow change subjectively or objectively. It seems to me that the term means what the term means. Where I think that somehow the objective becomes involved is the issue that we're looking at here indicates that we're supposed to determine whether there's some evidence which could reasonably justify conviction. And so now I think we're back to, if I may, injecting the objective back into the scenario, because we have to have a reasonably justified conviction. So it doesn't seem.
But that depends on whether the jury question is what was the defendant's honest belief, or what was the defendant's legal, what was he legally allowed to believe. Because if you're only talking, did he really believe he needed to do this? It's a matter of sincerity for a jury question rather than the legal aspects, rather than the circumstances that existed.
Well, I think that, I don't know if I'm answering the question, but I think that even in this case, you don't even get to there's no honestly held belief, because it's Mr. Roeder himself who tells us his beginning, his foundation is that it's not up to man to take life. And yet that's exactly what he did. He has no honestly held belief that he is able to do this, or should be able to do this, or can do it, either under man's law or God's law. And furthermore, I think that he's always, his testimony when taken in totality has always indicated that his true goal is to stop abortion. Not late term, but abortion. And that, even I think in the record, Mr. Roeder indicates is completely legal. So similarly to counsel's argument in the brief and here today, I think once we get down to one question, we can just we shift focus to another. And I think that one of the true problems with the instruction in this case is the term imminent. It simply wasn't. We need to look, nope, we don't need to go to Maryland. We don't need to go anywhere. We just need to go to White. And I think that's what the district court did.
I want to ask you about that because it's been bugging me. I realize you argue the facts that you have, but I'm concerned that focusing too much on imminence puts us in a scenario that suggests that, well, it would have been okay to shoot the doctor in the parking lot going in that morning.
Okay.
And so is there a danger in focusing? I guess this what's bothering me.
Okay.
If we focus too much on imminence, isn't there a danger that becomes the view that we just pick the wrong time to do it?
Next time, as long as I catch them in the act,
Right.
I can kill people. And that's not my point. My point was to try to bring us back to what the question was before the district court. And I think that, and again, I think under the statute, there has to be some evidence which would reasonably justify conviction of the lesser, and that has got to mean that there has to be some evidence of all of the elements of the lesser, not just some evidence of some of the elements of the lesser. Because if there just has to be some evidence of some of the elements of the lesser, well, someone died, and that's an element. And so I guess what I was suggesting is, to me, the clearest element that is unfulfilled would be imminent. And in that respect, the district court did not err in not giving the instruction, because there was, just as in White, there was no, I believe it's in italics, unless that's what Westlaw did. I think it was Chief Justice's opinion, but no is in italics. There was no evidence of imminence. And under what we understand the case law to be, again, it's not that, there's no question about certainty. It was specifically excluded by this court. So I'm sorry, Your Honor, I don't mean to indicate that everything else was fulfilled except for that prong. I'm just suggesting that that is somewhere, pardon the expression, but that's somewhere where you could shop and easily get an answer to this question.
Just suggesting the easiest way to dispose of the case, this particular case on its particular facts.
I think, well, okay, and I think that that's what the district court's duty is when the district court is charged with the duty to make this decision. Well, I don't need to go on to the, and I think he did, though. I think he clearly made rulings based on unlawful as well.
Could you go back to what you were saying about the honest element? And I think you were saying that this wasn't, I think you said this wasn't an honestly held belief because he killed a man, and yet his belief is that, one man can't take another man's life. But isn't that what makes it unreasonable? Isn't that what proves the element of unreasonableness?
Well, I think
And
that,
what does that have to do with whether he honestly believed it or not?
you know, that the unreasonable but honest, that's the phrasing of this is I don't know, counterintuitive. It's difficult, but when you roll it together, I think it was the amicus brief that I think hit this closely. The idea is that there's a mistaken belief that the circumstances are such that deadly force is justified, and it wasn't. The evidence was that he was aware that the existing law did not justify deadly force. He simply disregarded it. I think that's the best I can answer your question. Is
So it wasn't honest?
It
I mean,
wasn't
because you were
honest.
talking about, I wanted to focus on the honest
Yeah,
aspect.
it wasn't.
What does that mean?
It wasn't honest for a number of reasons. I'm sorry, Justice Johnson.
No, you go.
His personal beliefs interfere with it, and it's not honest because he was aware of what the status of the law was. He just didn't agree with it.
It's a kind of civil disobedience, really. And then when you do that, part of the rubric for civil disobedience is that you accept the consequences of your actions. Isn't that what you're saying, really?
Yeah. And I think that's why he's pushing so hard for, mistakenly so, perhaps for the necessity defense. But even then, it fails.
Let's take it back to the legal analysis. That you're speaking factually, whether
Okay.
really
I'm
factually he had no, and that's your argument. But my question is, and what I'm trying to nail down is whether the honest belief to which the statute refers only applies to the words that come after, that circumstances existed, rather than the justified deadly force under the statute. And so what I'm getting at here is if he honestly believed that a failure to follow the right procedure, get someone to sign off on a second opinion or whatever, under these three statutes, under one of those three statutes, would have legally permitted deadly force, but we determined no, deadly force would not have been legally permitted by those. Does he nevertheless get the instruction because he had a misinterpretation of the law? Or whether the statute speaks only that the honest belief has to be to mistakenly believe that the circumstances that would have been legal existed?
I think honestly modifies all of the other elements. I think the whole.
So you think of ignorance of the law would nevertheless give you the voluntary manslaughter instruction if you misinterpreted what's permitted in defense of others or self-defense?
Maybe I'm misunderstanding the question. No, I don't. I do not think that an ignorance of the law would support your, and that's what I thought I had. And I'm going to go back to the facts again. I'm sorry, but that's where I think the amicus brief hit on it. Where it's not that he didn't understand; it's that he consciously disregarded it. I'm sorry if I haven't answered the question.
It can't be, if we put together the presumption that everyone knows the law, it can't be an honest belief. Is that what you're saying?
I would agree with that. And then to go back to these facts, clearly he understood what the law was. Unless the court has any questions on any of the issues.
I was going to ask if you had a response to either of the hypotheticals that were posed or analogs that were posed this morning, the ventilator.
There were
and
quite a
then
few.
Well, the ventilator and also
the
the tobacco
ventilator.
CEO, if you could address those.
Oh,
If you recall them.
I
would you
recall
like-
the ventilator more than the tobacco CEO. The ventilator, the question was what was the difference between the two scenarios, gosh, I'm sorry.
Why don't we ask Justice Biles to restate the ventilator scenario, and you can respond to that if you have a
Thank you, Your
response.
Honor.
Well, you're just at an end-of-life situation, and the family directs the physician to turn off the life-supporting system, and a stranger believes that that's killing the patient and kills the doctor
Yeah,
in the act of doing it. I wanted to both have a stranger involved, and I wanted it to be imminent.
right. And I think
I
that's
didn't
the
want to mess
question.
with that.
I think that's the question you followed up with me on. Why are we focusing on imminence? Maybe we're missing the point somewhat. I still think that the conduct would have been lawful. In your scenario,
The doctor's conduct.
the doctor's conduct would have been lawful. So we still have that issue, if that answers the question.
So in other words, there's no distinction.
No, I don't. Well, sure, right. Other than the eminence.
Yeah, I mean, the question is, if the defendant is correct in the legal argument that's being made, in my scenario, does the shooter get the voluntary
No.
manslaughter instruction? If they're right.
Oh,
And I think if they're
yeah,
right,
yes.
it sounds like the
Yeah.
shooter does.
And then I guess that would hold true for the tobacco as well.
And you could combine the two hypotheticals and say the person was in the hospital due to the CEO's company. So it could be a double
Yeah.
shooting.
I'll just smile and nod, I think, at that point.
I have a question about the hard 50.
Hard 50, yes, Your Honor.
We've essentially held in past cases that unless there's some sort of mental anguish or kind of terrorizing the victim prior to being shot with a firearm anyway, that victims killed by gunshots standing alone don't suffice for especially heinous, atrocious, or cruel. How does this case fit differently than those cases? I'm thinking of the Baker case, which I'm familiar with.
Is that Linwood?
Yeah, Linwood Baker, in which we reversed based upon that finding that there was no evidence of terrorizing the victim or mental anguish, even though the victim was completely defenseless in that case. Here, I think we can characterize maybe what happened as an ambush. Dr. Tiller was probably completely unaware of what was going to happen to him at the moment it happened. Shot, immediately killed. How is that especially cruel and heinous under the statute? Bear in mind, I'm talking about the statute. Just for everybody out there, we all understand that all murders are
That's
cruel
correct.
and
And
heinous, but this has to meet an exception. And how does that meet the exception?
Well, to summarize, and unless I've done it incorrectly, to summarize, how is this different than, and as you say, the run-of-the-mill premeditated murder with a handgun?
With a handgun,
Right.
and it's especially done in this case in which the death was immediate. There's
Very suddenly.
very sudden.
Yeah, and I
I-
think
again-
what the district court relied on were the statutory provisions, and one was the prior stalking, and I think that begins to set this apart.
Doesn't stalking require knowledge of the victim of the stalking?
I think the crime stalking, if you're going to charge someone with the stalking crime, it does. I don't think that the factor or sub-factor as formulated does require it, especially when there's a precursor.
How does it fit into heinous and cruel if there isn't any knowledge? That's basically what we've said. It's more cruel if you cause the person that mental distress in addition. But if they don't even know it's coming, I mean, stalking doesn't really fit into the category. You understand what I'm saying?
I understand, Your Honor, but it's my understanding that there's a precursor to the statutory provision itself that indicates that it is not necessary for the victim to have knowledge or be concerned for their safety, and I think that's what the district court probably had in mind. It's not necessary for them to know. When you put the two together, it's not necessary for them to know of the prior stalking.
If we disagree with you, then what aggravating factors
Well,
do we have other than being in the church?
Well, and maybe I'm pretty sure I'm right about this. It's the same factor. These are just subparts of that. Right. If you remove that sub factor, then we've got the preparation and plan, and then we also have the what the court found any other conduct. And I've heard it summarized, and I've, that it was just because it happened in a church, and I think that was the court's ultimate expression. I think behind that expression was, what does that really mean?
A place where he felt safe,
that it was a
sanctuary,
as
literal. Yeah.
correct. And as I process that in light of the preparation and plan and Mr. Tiller's intent, what I process it is this man, what separates us from a shooting, again, the run-of-the-mill premeditated murder shootings that happens quickly, is that this was more or less a terroristic act. The location, the event, it was meant to stop other people from seeking procedures that are protected by the Constitution. That's not present in Linwood Baker. That's not present in any other, well, I was going to say premeditated murder, but other case that I'm aware of. And I think that's what separates this out, is just the absolute terrorism, not necessarily of Dr. Tiller, but the terrorism of everybody else.
Including others that might perform the procedures.
Or receive the procedures. To me, it's not necessarily tied just to the performance.
So, but did the judge talk about that at all?
I don't know that he
don't remember.
specifically, and that's where I was to begin with. I don't know that he specifically articulated in that way, but I think that's what, when you read between the lines, that's what it happened at the choice of the location.
Did we have that argument at sentencing from the state's counsel? Do you remember?
Again, I don't think that it was articulated completely that way. I think that is the hidden message or reading in between the lines.
Okay, thank you.
Unless the court has, in the misconduct claim, I apologize, one of the duties is the 609 letter of additional authority. We relied on a case law that indicated that responding to actions of defense counsel, and it was never our, I keep looking over at Justice Biles because he issued an opinion like last week, I believe, that talked about how that's changed. It's changed in the last 2 years. It's changed after we wrote our brief. And we never relied on that case for the idea that you get to, if it's a free-for-all once the defense counsel does something wrong. In our brief, we were merely tying this court back to why the prosecutor even got involved in this discussion, and it was to bring the jury back from defense counsel's entire closing, which talked about the Trail of Tears, Hitler, Stalin.
It was almost a jury nullification argument, and it appeared to me as a response to a jury nullification.
And I think it was, but I didn't want the court to think that we were relying on that case law indicating that the prosecutor did something wrong. It's just that we were indicating that it was in response. So anyway, I realized that actually yesterday, as I tried to take a break and read back through some new cases, and that was a shock to me. So anyway.
Well, I have a little trouble saying it's new law because if you go way back to State versus Manning, I think that was Justice Abbott says that the open the door doctrine does not apply to prosecutorial misconduct in closing. So you had some law in the interim that seemed to indicate, but it wasn't a brand new concept.
Well, I think in our brief we cited at least 10 cases that indicated that, as you say, the interim, and Justice Biles' opinion brought that to the forefront, the change or not the change.
The prosecutor no longer gets a free pass, but it is a factor to consider in the calculus.
And just my point of bringing it up was to express that we never were relying, nor do I think we ever in any brief relied on the idea that it was a free pass. So unless the court has any questions, on any of the issues. We'd respectfully request that the conviction and sentence be affirmed, and we await the court's decision on the motion for supplemental briefing on the Hard 15.
Do we have any further questions? Thank you, counsel.
Thank you.
You reserve 5 minutes for rebuttal.
I want to jump through the Hard 50 real quick, just to address the points that opposing counsel just made. In answer to your question, Justice Breyer, there was not an argument presented that this was a terrorist act. The judge's ruling does not say that. He relied on 3 factors to make it aggravating, which under Alene shows it's unconstitutional. So there was not argued at sentencing that this was an absolute terrorism and that everyone was terrorized. So I want to clarify that was not an aggravating factor. Circumstance argued at sentencing, but just now. The 609 letter that the state referred to that didn't send regarding the prosecutorial misconduct, I'm not sure what case that is. If I find it necessary, I'll probably file, if I need to, a response, but I think it's common law.
It's maced from Friday.
Right, yeah, okay. The CEO who's now become the victim in the ventilator, I think we've combined both of those. I'm going to quote from Quayles. Under KSA 213403B, voluntary manslaughter requires. Now, what I'm going to read to you, Justice Biles, may fit your scenario. The beef this court may have may be with the legislature and how they've drafted this statute. We're only presenting a defense that the legislature has presented for defendants who have this unreasonable honest belief. Under KSA 213403, and this is how I began my brief, of this is what is put in the statute. Voluntary manslaughter requires an unintentional killing. That is committed with the unreasonable honest belief. Here it is, your person who thinks that the person about to put to death, taken off the ventilator, should not be done so. That circumstances justify deadly force, and here I'm going to go ahead and shoot this doctor, to defend against an aggressor, the aggressor being this doctor who's about to stop the ventilator. Imminent harm, use, and you've just said that, the doctor's about to stop this person getting off the ventilator, of unlawful force. That's why I kept on harping of how is this unlawful. In Mr. Roeder's case, there were charges against this doctor showing it's unlawful. But in your scenario, let's just add unlawful to it. Under KSA 213211, your scenario may actually fit this statute.
The difference in Qualls, which is why, which of course I wrote, but the difference in Qualls is that the factual scenario in which the arguments are made were objective. That's where I get back to my earlier question of you about when you're jumping in and out of objective versus subjective. In other words, we know from the facts of Qualls that we had a bar fight, and we had the defendant testifying that he thought the deceased was reaching for a gun. Mm-hmm. And the objective facts lend some notion of credibility to the subjective, and then the rest of the case gets down to whether there was any evidence that would just refute the subjective belief, which again is going back to an objective scenario. So I don't see Qualls myself as simply letting the defendant's lens control literally every element of the manslaughter thing. That you actually can take the lens, put it in an objective context, and then see whether the jury could reasonably find, which gets back to the Chief Justice's point, whether the jury could reasonably find something. And my concern with your argument is that you're trying to use subjective throughout the four corners of every element of the statute. Mm-hmm. So that would be my distinction with Qualls. Now, you may disagree with that, and that's fine, but that's another way of looking at Qualls.
Right, right.
Which then doesn't fit what you just said.
Right. Qualls, I think, is the classic scenario of why the legislature enacted voluntary manslaughter. that bar room scene where somebody thinks they're about to be attacked or they're not. But they haven't limited it to us. They haven't limited us to that. The way this is written is, and that's why I get too subjective, is unreasonable but honest belief that circumstances justified. Here you have that. Deadly force to defend against aggressor's imminent use of unlawful force. So that's the lens that I'm using. I'm saying we get to take a subjective, and as you said, not all fall corners, but look at it from his point of view. Again, this person will still be convicted of a crime. The legislature has found those who have this and act upon this viewpoint are convicted.
How do you respond to the state's argument that it couldn't possibly be an honest belief because the defendant had said that a man shouldn't take another person's life? And so, in fact, now he's taking a life.
My response to that is issue 2. Issue 2 is a quite lengthy issue. It's talking about how the defense was never able to present a full, complete defense of voluntary manslaughter. How basically the state was able to bring in the motel clerk where Mr. Roeder stayed that day, and the person who showed him the gun. But Mr. Roeder was all by himself. He only had 2 witnesses he wanted to bring in to show this is how I got this belief. The honesty, the unreasonable but honest belief that circumstances justify this. So that's how we see a distinction.
That testimony would not have gone to the act of killing. It had to do with whether there was probable cause to believe that Dr. Tiller was acquitted when he shouldn't have been, was the way I was reading that.
No, in my reply brief I explained that this testimony was important for his view that this was unlawful. Think of the 1992 LA riots. 4 police officers are acquitted of abuse against a pedestrian. People who watched that trial thought those police officers were guilty. They had this, even though these officers are acquitted, you have people in riots upset about that. That is their viewpoint. So,
But the difference is the unlawfulness that he wanted to bring in from Mr. Disney, Mr. Klein, had to do with the procedures that had to be followed, not with regard to establishing
Right.
that the abortion was murder. And he believed the abortion was murder, which gave him the subjective belief that he could defend that
yes, see, I see it.
other.
Yes, I'm seeing it from a different.
But there's a difference. If you believe someone's jaywalking, I mean, that's you have to believe that the unlawfulness is deadly force type of unlawfulness, not just a procedural problem. And if we determine that the failure to keep the right paperwork did not make Dr. Tiller an aggressor performing unlawful deadly, exercising unlawful deadly force, then the statute would not have legally given the right to kill him to protect against the statutory problems.
Yes. You're
And
drawing.
at that point, that's we're back to the
first question.
is the reasonable but honest belief is in the misinterpretation of what is permitted to be done to rectify what was the believed unlawful conduct. In other words, even if we believe that he believed the 2 witnesses he had, and he believed those circumstances existed, if we find those circumstances, as he honestly believed, would not have justified his act, then does he get the voluntary manslaughter instruction because the rational jury could not find guilt? You follow what I'm asking you?
I'm not sure.
Because the unlawful conduct in which that you're saying he believed Dr. Tiller was involved in wasn't murder.
Right.
It was failure to get a second opinion that justified the procedure.
Right.
That's what he's getting at.
And what I'm adding to that is you're seeing this as a procedure, but I'm trying to tell you, he saw this.
He saw it globally. You're saying he saw it globally rather than
Well,
distinct.
he said, what did you feel like after he was acquitted, frustrated, like I had to felt like do something, like there was nothing else to be done to stop this. So he saw these procedures, as you say, paperwork, as more as, and this is your answer to your question, Justice Rosen, he saw it as part of the that these were lives being taken.
And that just leads me to what, in any first-degree murder case or in any murder case, it seems to me what you're suggesting is a voluntary manslaughter instruction can be given on any subjective thought that the defendant has as to why he or she acted in the way they acted. I mean, what's to prevent any kind of irrational belief, whether it's sincere or not, to allow and that isn't what the legislature intended by having an imperfect self-defense or a voluntary manslaughter instruction. It's limited by what's confined in the law. And you're basically suggesting there is no limitation.
I'm suggesting our argument fits within the parameters of the law because of what I've gone through, the circumstances that he sees, different from the circumstances you've described, Justice Johnson, that justified deadly force to defend against aggressor. All these are being defined as we go along. And the barroom fight that Justice Biles, quails, that's the quintessential. But that would be what you're talking about. But this case still, the way the law...
The difference is, the circumstances in Qualls is the defendant believed that the victim was pulling a gun.
Mm-hmm.
And under the statute, if you read the statute, that circumstance, if it had existed, would have permitted regular self-defense. Here, if the circumstances existed exactly as the defendant believed them to be, then defense of others was not permitted, was not legally permitted in this case, even if everything that the defendant believed was true.
Because...
Even if the abortion to be performed first thing Monday morning did not have the requisite second opinion and the paperwork, still that would not have justified deadly force.
Because I'm not supposed to ask questions. I want to clarify your question. What is missing in this case? Unreasonable, honest belief, circumstance exists, justified, I'm reading from the statute, under KSA 213211, KSA 213211, use of force. Persons justify use of force against another to the extent it appears to such person that such believes that such force is necessary to defend a person or a third person against another's imminent use of unlawful force.
The unlawful part. He's saying that's not true.
That's not true.
That's not accurate, objectively accurate.
Right.
Because
Right, and our point is, this is why they've created a statute for this, for somebody who thinks that another person's actions are unlawful, but they actually are. That's why I'm saying the unreasonable honest belief is we get to,
What
my
we're talking
argument
about
is...
here is there's a factual misperception and unreasonable belief that certain circumstances existed, factual circumstances,
Right.
and there's a misinterpretation of the law.
Okay.
Clause involved a factual misperception. Believed there was a gun being drawn, it wasn't. Here, the only way you get there is to allow the defendant to misinterpret the law, to believe that deadly force was justified, even though the circumstances that were present and he believed were present would not legally have justified it.
I think we're back to where we were.
Counsel, I see you're out of time. Would you like 30 seconds to wrap up?
Yes. Despite all your questions, The question still remains, should Mr. Roeder have been convicted of first-degree murder? This was a simple jury question. We believe that there is some evidence here, that's all we need, that's the framework, in the light most favorable to Mr. Roeder, to which he could argue that there were circumstances that would justify deadly force. Because we don't know that answer, because the jury instruction was never given. He was not given a fair trial. We ask this court to reverse. We also ask this court to keep a lien in mind in reversing and vacating his hard 50 sentence.
Very well. Thank you, counsel. We thank you both for your arguments this morning. The court will take this matter under advisement. Since we